Well, as Marshall said, my name is Victoria Beckman. I'm located in Columbus, Ohio, in one of the 13 offices that Frost Brown Todd has across the Midwest of the United States. And we're going to talk today about data privacy laws, mostly in the United States. There will be some mention of the GDPR as an introduction to our laws. And the learning objectives are to be aware of recently enacted and proposed legislation related to privacy and cybersecurity requirements. And granted, when I prepared this presentation, the most recent federal proposals related to privacy and COVID were not even on the table. So we may mention those later, but what was enacted or proposed up to last month. Understand potential legal risk for an organization in the area of privacy and data security, prepare the organization to be compliant with requirements of the law, and have a better understanding of legal trends in regulation and enforcement of data security related laws. As always, I have to mention the warning that this is not legal advice, it's just a presentation. And let's look at kind of the agenda that we have today. We are going to talk in general about privacy laws, including, as I mentioned, the GDPR, the CCPA, and some similar proposals in other states of the United States. We're going to talk about breach notification laws also in the United States, incident response requirements or incident response plans, some mention of biometric laws, some cybersecurity requirements in the insurance and financial industries, SEC disclosure, that's the requirement that they established, it started in 2018. Other federal laws, we will not discuss those in depth. We're just going to mention that there are other sectorial laws that are regulated and a little bit about Internet of Things. Before we start, and most of you probably know this, as privacy professionals, but I wanted to make sure that I mentioned the difference between privacy and data security. They kind of work together, but security and privacy are two separate things. Security has to do with securing data against unauthorized use. So that's when we talk about data breaches, any technical, administrative, and physical safeguards that you can put in place for the information, incident response, standards, frameworks, whereas privacy relates more to the actual authorized access to the information. So the privileges that you give to the users, what requirements are dictated by the law, best practices for privacy, and the laws that give rights to individuals and impose obligations in the organizations as to how to process this personal information. So at some point, these two come together. And we talk kind of indistinctively about them in the law, but those are two separate areas of the law. So far, in the United States at least, most people consider personal data the basic information: social security number, date of birth, financial information like a credit card number or an account number, and a password. So normally, if you talk to a client that has suffered some kind of data breach or data incident, a lot of times they will say, well, there wasn't a social security number or a date of birth, we're fine, we don't have to worry. And unfortunately, that's not the case. With different laws and laws evolving and being amended, the definition is really broad under recent regulation, one of them being GDPR, for example, and it could include things like photos, an IP address, an email address, a phone number, a first and last name, and biological information. And in fact, under the CCPA, the California Consumer Privacy Act, which we will discuss later, information or personal information is defined as any information that identifies, relates to, describes, is reasonably capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So that definition right there shows how broad it is and how having other information about your clients, for example, if you're an organization, you have to consider all these regulations and privacy laws. So let's start with US privacy laws. Well, unfortunately, we do not have a federal law. We don't have something kind of GDPR, and each state is attempting to regulate on their own. So far we have the California Consumer Privacy Act that, again, I'll discuss a little bit further. That was modeled after the European Union General Data Protection Regulation, or GDPR. Is fairly similar because of the history. It was kind of rushed, and it was drafted and passed almost overnight. So it has some inspiration on GDPR, but it also has some differences. And then after the California Consumer Privacy Act became effective on January 1st, 2020, some other states started kind of doing the same to a same degree or a lesser degree. So Nevada and Maine had some regulation for website providers last year, 2019. And then this year, in 2020, we have seen all these states, New Mexico, Massachusetts, South Carolina, New York, Pennsylvania, you name it, that have proposed similar bills. Some of them are almost exactly the same as CCPA. Some of them are a combination of CCPA and GDPR. And some of them, like Illinois, for example, extend a little bit farther than CCPA. Some of them, like Washington, have failed twice to pass, and Virginia tabled it for next year to do some more research as to whether or not they should consider it. And then there has been a lot of federal initiatives, including one this week or last week, I don't remember now, but related to privacy for COVID-related information in terms of health information during a national health emergency, what to do with the information, when to discard it. And unfortunately, nothing has come to fruition because there's been some disputes on the lines of the different parties. And it seems like they always kind of advance and get to the point where there is a dispute. The two major points of dispute are whether or not it will preempt state law. Because with California, for example, we have a pretty strict law, whether or not the federal law will preempt that. And also, by the time that some federal initiative or federal bill becomes the law, probably a lot of other states will have had enacted similar to CCPA regulations. So at that point, which one is going to be, whether they're going to be preempted or not. And then another issue of contention is enforcement and whether or not to give a private right of action to individuals and a private right of action for all violations, or just for certain violations like a breach in the case of CCPA. So I said I was going to talk a bit about GDPR just because it seems like the GDPR inspired CCPA and copy a lot of the concepts. So just really quick, I know that we have some people from the UK and from Europe, so they're the experts on this. But in general, the GDPR became effective on May 25th, 2018. And it kind of expanded the definition of what we normally knew as personal data, also to include a lot of information and to consider special categories of information, like information about religion, politics, things like that. And what was unique and why we care about the GDPR in the United States and anywhere outside of the European Union for that matter, is because of this extraterritorial effect that it has. Meaning that even if you are not located within the European Union, if you are offering goods or services or targeting data subjects in the European Union, you could be under the scope of the GDPR and have to comply with it even though you're located in the US, for example. It also requires lawful basis for processing information, meaning that it must be necessary, and gives these 6 different lawful bases that you can have. One of them being consent, and the issue with consent here is that it could be revoked at any time. And in the US, normally we have relied heavily on consent and nothing else for the processing of information. It could be, the lawful basis could be contract, contractual relationship, legitimate interest of the business, legal obligation. Granted, that legal obligation needs to be based on European Union law. So for US companies, that option is really not available. You can say that you have to comply or process information one way or the other because of some kind of federal statute, because this is the GDPR is European Union law, and the legal obligation must be based on a European Union law obligation. Vital interest, and that has been discussed now with the COVID-19 of whether or not the information has to be processed, and whether or not it's a vital interest or a public task. Same, whether, you know, organizations, hospitals, things like that need to process some information, health information, now during the pandemic as a public task. It also has this concept of data subject rights, meaning that it will give different rights to the data subjects, like the right to access, to rectify the information, to port the information, and the very famous or infamous right to be forgotten. You could also object or reject the automatic individual decision-making. So it gives all these rights to individuals that, at least in the US, we didn't have before CCPA. It also gives a timeline to respond to these requests. So an individual's request to, let's say, erase their information, you have 30 days from the date of the request to reply or to respond. And it also imposed these 72 hours to notify supervising authorities about data breaches. And let me just clarify, this is not to the individual data subjects. This is to the supervising authority of each country, whatever supervising authority you're under. But still, 72 hours is a pretty wild concept, considering that if you have ever done any data breach response, normally whether the company is prepared or not prepared, whether they have an incident response plan, when there is a breach, kind of everybody goes into panic mode, doesn't necessarily know what to do. Most of them happen on weekends or Friday afternoons, and 72 hours is really not enough time to realize what happened, to stop a breach, to come up with a statement that is consistent, that is going to be kind of the official statement of the organization to the authorities and later to the data subjects. So the 72-hour requirement was kind of a new concept where we were all surprised, but it has slowly become the standard. I've seen a lot of contracts, even in the United States, that are not subjected to GDPR, but it still give the 72-hour standard to inform business associates or to inform vendors of a breach. It also gave a private right of action and the enforcement and penalties by supervising authorities, which are pretty high because they could be up to 20 million euros or 4% of your annual global turnover, which could be potentially, if you get fined and you're not a Google or you're not an Apple, that could take your company to bankruptcy if you have to pay something like that. And as I said, the CCPA kind of inspired the GDPR kind of inspired the CCPA. And so the CCPA became effective in the United States on January 1st of 2020, this year. And the reason why I have an asterisk is because enforcement is not supposed to happen until July 1st of this year. Although there is a lot of questioning of that right now, because the Attorney General of California was asked about 2 months ago, was asked to delay enforcement because of COVID. And in fact, he received a petition from about 600 different companies asking to delay that enforcement. And he's been very, very emphatic in saying, no, we're going to start enforcement on July 1st. However, there are proposed regulations that have been amended twice. The latest of this proposed regulation was issued on March 11th, I believe, and they haven't been approved. And also, there is a requirement in California that the California Office of Administrative Law needs to conduct a review of these draft regulations once they're finalized by the AG, which hasn't happened. And also that it has to be, that normally it gives them 30 working days to complete this review, which has also been changed because of COVID, given 90 days for this review. So technically, it will be impossible for the regulations to be ready and to be reviewed by the Office of Administrative Law and be enacted before July 1st. So we are going with the assumption that the regulations are going to be enacted as the draft that we have now. And that's how I'm advising our clients to comply, assuming that they're going to be fairly similar and there are not going to be many changes to the latest draft. So CCPA also has covers California consumers, and California consumers are defined as California residents. Kind of funny enough, residency is based on Title 18 of the California Code of Regulations, which is a tax code. And it basically says that a resident is any individual who is in the state of California for other than temporary or transitory purpose, or every individual who is domiciled in California who is outside of the state of California only for a temporary purpose. So pretty much anyone with an address in California. It also has this expanded definition of personal information, as I mentioned before, anything that could be related to an individual directly or indirectly, or even a household. They kind of have this concept of a household and is defined under the Act. It only applies to for-profit organizations that fall under a threshold, the threshold requirements of income and how many individuals they're processing data or following. So there is a threshold. Not all companies have to comply, but because of this threshold, it also kind of like GDPR has this extraterritorial effect in that if you are a business in Ohio, for example, but you collect information of California consumers and have, let's say, more than a 25 million annual income, you'll have to comply with CCPA, even if you're a business located in Ohio, in Florida, or any other state of the United States. One of the main principles or requirements of CCPA is to have a privacy policy, and this privacy policy needs to explain how data is collected, the purposes for this collection, whether it's shared, with who, with what parties it's shared, and it also provides consumer rights, kind of like GDPR. It also gives 45 days for a company to respond to consumers' requests, and just like GDPR, there are some special circumstances when you could delay and could ask for extra time and respond in 90 days, but for the most part, you have 45 days to respond. And civil penalties by the Attorney General and a private right of action out of a breach of certain information. So not everything, there has to be a combination of driver's license, name, last name, some specificity, but it's basically anything that causes a breach because of negligence in keeping the information. And as I mentioned, there are these proposed regulations that have been amended twice and that are still not finalized. So, I'm sorry, I'm just reading. I have a question. Okay, the question I have is, what is the meaning of PI and expanded definition of PI. And PI is personal data, and what I was trying to explain was that normally personal information was considered the basics: social security, date of birth, passwords, and with this, what we are calling expanded definition is that pretty much anything that can be traced back to an individual will be considered personal information, including an IP address or a photo or something like that. Okay, so the new California consumer rights, as I said, fairly similar to GDPR. We have the requirement to provide notice to consumers before or at the time of collection, which has been in practice a little challenging because there is no mention in the CCPA about cookies or management of cookies. And some companies wonder whether if someone comes to your website and you're deploying cookies right away, how are you going to ask or give notice before collection or at the time of collection if you don't have some kind of requirement to have a cookie banner or to explain the cookies? So in practice, that has been hard to advise, and I guess it comes down to what kind of cookies your client has and how you word your privacy policy. It also allows for consumers to opt out of the sale of information. In this case, it requires a separate link in your website that says, "Do not sell my personal information." And one of the tricky things about this is the definition of sell under the CCPA, which is either selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating orally or in writing by any means the personal information of a consumer to another business or third party for monetary or other valuable consideration. And what other valuable consideration means has been debated for a year almost now. Because it's not defined in the Act, and also there are questions as to whether just transferring the information to a third party to provide a service is valuable consideration. So there is a kind of an explanation in the definition as to whether an entity is a service provider or a vendor, and whether or not you're selling the information. And in that sense, it's also recommended to review the agreements that you have with those third parties to make sure that if there is an exchange of services, the definition of why the information is being shared is not for purposes of a sale, that no one is getting consideration. So there is a lot of work that we have been doing and that organizations should take into consideration as far as reviewing those agreements with third parties and wording them in a way that takes that transfer of information out of the definition of selling under CCPA. There is also the right to know specific information. It has this requirement that if I'm a consumer and I ask for my information, the company needs to provide 12 months prior of the date of my request as to who they have shared information with, the sources of that information, whether or not it was for sale, and some other requirements. So companies in the US, even though it only became effective on January of this year, needed to be prepared to have that information for the previous 12 months. It also gives the right to delete the information, and there are some exceptions that we will look at shortly. The right to port your information and the freedom from discrimination, which means a business cannot deny goods or services to the consumer or charge different prices because the consumer is exercising his or her rights under CCPA. Okay, I have a question here. Is it safe to generate a privacy policy with online services in an automated way, or do we have to work with a professional? Well, that's what I do for a living. So I would say that you should work with a professional. But really, I do recommend working with a professional because that's something that I see all the time. Clients saying, well, we get a template or we copy a template from here or there. A very, very important thing with a privacy policy is that it provides notice to your users of what you're doing or not doing with the information. So a template is not personalized to your organization. It may say, for example, that you do behavioral tracking or that you use certain cookies that you don't. And then if your privacy policy is not accurate, then you're also opening the door for potential actions by the FTC for deceitful practices. So I think it's important to have somebody who knows about this and that can tailor that privacy policy to the real needs and real processes in the internal processes of the organization. Okay, and here are the exceptions to the right to delete, because this is a difficult one for companies to comply with. But there are a lot of exceptions, and a lot of times we're able to fit this, the request to fit within one of these exceptions. So to complete a transaction, to detect security incidents, to repair errors, a lot of them is, I can't delete your information until I process your order, engage in peer review. So there are different exceptions, and there's an exception not to the right to delete, but an exception as to employment-related information that is not covered by the CCPA. Just for now, it has a sunset clause, meaning that that exception was provided until December 31st of this year or January 1st of next year of 2021, just to allow more time for companies and HR departments to get ready to process and come up with all the internal processes for employee information. And as I mentioned, there's also penalties and enforcement. There are civil penalties by the Attorney General for violations that are not cured within 30 days. And again, this has also been an issue of contention because people say, well, how can you cure a data breach? What does it mean that you're curing some kind of issue? And we don't know because it hasn't been, enforcement hasn't started yet. But the Attorney General could give up to $2,500 for each violation if it's not cured within 30 days, and up to $75 for intentional violations. And as I mentioned, it gives a consumer a private right of action for a breach. And the breach under the Act is defined as any consumer whose non-encrypted or non-redacted personal information is subject to an unauthorized access and exfiltration, theft, or disclosure as a result of the business violation of the duty to implement and maintain reasonable security procedures and practices. And again, issue of semantics. There is no definition as to what reasonable security procedures could be, but based in other laws and based in industry standards, it is fair to assume that if you follow something like NIST or ISO or some of those recognized frameworks, you are maintaining reasonable security procedures. How to comply, and this is obviously a very simplified list and version of what we recommend our clients should do. One of them, just like in GDPR, and although it's not mandatory, is to have a data map to know what information you have, where it's stored, who has access to it, how does it flow, etc., whether you need it or not. To create internal processes to fulfill the requests from California consumers and other requirements. So this means documenting, for example, how are you gonna process consumers' requests? Is it gonna be a manual process or is it gonna be automatic? Who is gonna take care of those? How are you gonna respond? Because there are also dates when you have to tell the consumer that you received the request, that you're processing. If you need to delay a response, who is going to do all that? How are those responses going to look like? Where are they going to be stored? Who is going to keep records of this request? Because there are also requirements to keep certain records, and for how long. So creating and documenting all those processes is important, just like with ISO. So if I'm in charge of this request in my organization, I leave the organization, anyone else can come the next day and get it done. Important to say that you cannot discriminate against California consumers. So there is some portion of the act that talks about loyalty rewards that are different from charging, for example, different prices if the consumer wants to exercise his or her rights under CCPA. So you need to make sure that you don't do that. As I mentioned, update third-party agreements to make sure that you're taking your agreements out of the definition of sale under CCPA because of how encompassing that definition is. Obviously, review and implement security practices and procedures so you don't suffer a breach, and because you have the obligation to keep the information of consumers protected and safe. Conduct employee training. The act actually requests that anybody that is involved with CCPA has to be trained to take calls, to take requests if that's necessary, and to know, where the privacy policy is and how to respond to those requests. Review and update required disclosures, which means reviewing your privacy policy. It is a requirement under the CCPA to review it at least annually, to show the date when it was last reviewed, and to let consumers know if there has been significant changes. And comply with the opt-out and opt-in requests, meaning having the link in your website if you have to have it. And then there are opt-in requests, which also has different requirements if you already opt out before, if you're a minor. So there is also separate processes for opting in. Okay, now data breach notification. Like most things in the US, we don't have a federal data breach law. Each state has its own different data breach notification law. So we have 50 different state laws, and in fact, and I put the asterisk there because it's actually 54 if you were to include the Virgin Islands, Puerto Rico, Guam, and the District of Columbia as separate states, which means that when we have a data breach in the US, and let's say a client contacts me, you have to comply with all these different laws. For the most part, they're pretty similar, but there are a lot of differences into, for example, whether or not you have to notify the Attorney General of the state based on the amount of records that were compromised. Some states like Ohio, if you have more than 500 people, you have to notify the credit bureaus. So the main three, TransUnion, Equifax, and I'm forgetting the third one, Experian. And some of them also require some notification to the police department, for example, like in New York. Some of them require credit monitoring for the victims of the breach, and some of them require 12 months, some of them 18, some of them 24 months. So even though the notification that goes out as a letter to the victims could be a template, you have to know the differences between the states and account for all those differences and make sure that you follow the specific state law. Some states, for example, require that you notified the individuals first before you notified the Attorney General, for example. And some states also require a written information security program, or WISP, like Massachusetts, for example. And part of that WISP is an incident response plan. So there are obviously other laws that go into, while there is not again, not a federal law as to what you have to have, whether or not you have to have a WISP, whether or not you have to have an incident response plan. All of these are part of keeping the information protected and avoiding a data breach. So it is important to consider this and having your company prepare to have both of these, the incident response plan and the written information security program. Also, because in the US, we have the attorney-client privilege, which exists in other countries, but is not enforced the same way or not used the same way. For example, in Latin America, there is an attorney-client privilege on paper, but it's really doesn't really work the same way that works in the United States. So having all this and having somebody, a professional, an attorney that can help you with this is helpful, because the moment that there's a data breach, attorney gets involved, like in my case, all this information, all this, how you deploy the incident response plan, for example, forensic reports, things like that are protected under the attorney-client privilege. So you don't have to disclose them as part of discovery if you were to be subject to a lawsuit in the future. Okay, other important laws in the United States, we have biometric laws. And so far, we have only 3 states. We have Illinois, Texas, and the state of Washington that have this. We have Arizona and South Carolina with pending laws to be enacted. They were introduced this year in 2020. And the majority of these biometric laws basically say that you need to provide notice before collecting, using, or disclosing biometric information, normally applied to the cases of employer and employee, that you have to have written consent from the employee, that you cannot sell the information. However, in Texas and Washington, there is no private right of action. The enforcement is done by the attorney generals of each state by fines. In Illinois, there is a private right of action under the Biometric Illinois Protection Act, BIPA, and there's been a wave of class action lawsuits, including one that was set up by Facebook, because of violations of this and because of the definition and the argument of the definition as to what constitutes harm. Does it require that someone actually steal your information, or is it the fact that it's biometric information authorized by an unauthorized party? Is that enough to constitute harm? Because you really can. It's not like if someone steals your password where you can go change it. You really can't change your biometric information. So the Illinois Biometric Act is the subject of very active class action litigation in Illinois right now. And then other relevant laws related to privacy or cybersecurity in the United States that normally we consider is laws related to Internet of Things. We have California and Oregon with these laws that are mostly for manufacturers, stating that they can have universal passwords or a universal way to set up the device, because it is subject to breaches, and that they have to have some kind of reasonable security. We have the NAIC model laws, and NAIC is the National Association of Insurance Commissioners. They came up with a model law as to what they think is the perfect law related to cybersecurity, and 8 different states, Ohio, Michigan, South Carolina, Mississippi, Alabama, Delaware, Connecticut, and New Hampshire, I believe, have adopted their own version of this model law, which basically has cybersecurity requirements for companies involved in the business of providing insurance. And they're pretty similar to NIST or ISO as well. It's just basically a cybersecurity framework that should be followed to keep the information secure and to show, in the event of a data breach, that the company wasn't negligent in keeping the information secure. We have the SEC disclosure, And the SEC came out with a memorandum in 2018, basically saying that companies should consider the materiality of cybersecurity risk to investors. So the SEC basically said, when you are telling investors about risks, the same way that you tell them about political climate, about the economy, about things like that, you need to disclose cybersecurity and the potential risk of a breach or the potential risk of having an issue in that area as something to be considered by investors before they make the investment. And they actually have to be disclosed in some of the disclosures that are required annually or quarterly by companies. Social media, which I will describe a little bit. And then, as I mentioned, there are other sector-specific laws. We will need a whole webinar for those, which are HIPAA or FERPA or the PCI DSS or credit card standards. And social media, I normally talk about this because it's important for employers to know a little bit about them. And I'm not necessarily talking about whether or not you can ask your employees to not to post things in social media or not to represent that they're with your company or things like that. It relates mostly to whether or not you as an employer could have access or request access to the employees' social media accounts or to the logins and credentials, basically. And there are some states, as we can see there, this map is not necessarily very clear, that limit access to social media accounts, meaning you can't really ask your employee for their credentials. And some of them, 3 of them at least, have that you could have some limited access as long as there is not a retaliatory action against the employee because of something that you found in their social media account. And I crammed everything as fast as I could. But the takeaway of this, at least in the US, is that, as you can see, there is a lot of different laws. Unfortunately, the majority of the laws are based on, are per state. So we have to deal with a lot of different laws when it comes to privacy or even cybersecurity. We have more that are constantly being proposed and enacted. We have had a bunch of federal proposals, for example. But my recommendation is to be aware of all these laws. It doesn't have to be perfect in your organization, but you need to think about the processes, the budget, the resources that you're gonna need, because it could be expensive to have somebody reviewing this or implementing some kind of privacy policies and teams, but it is definitely cheaper than if you are a victim of a data breach or ransomware and then have to deal with attorney's fees, with notification, with things like that. Also, and I'm glad that I got that question, another takeaway is that it's not just having a pretty privacy policy that sounds and looks good and mentions all kinds of different legal words. If it's not an accurate description of what your organization truly does with the information and how they process it and how they dispose of it, and things like that. And so because of that, it's not a kind of a one size fits all. It has to be tailored to your organization. It has to match the needs, the size, the type of information collected, the nature of that information, whether it's sensitive or not. And also that data breaches may trigger a lot of legal requirements that companies sometimes don't consider. So a lot of times I have clients that say, well, you know, we uploaded this into this server, but it was there for 5 minutes. It's not a big deal. And then it turns out that it is a big deal, that you have to notify, that you have to change things to show to the attorney generals, for example, that you took measures to fix it, that you change your policies, or for example, with phishing, that you somehow came up with training to avoid phishing. So consider all of those things when you are thinking about privacy. and consider that the cost of not complying may be more expensive than actually doing it now.